Access granted.
Ayu, ini. Why do you ask? You look so tired.
I have received some complaints about you that you're hiding some things. They said that you were pregnant. Is it true?
No, I'm not pregnant.
Tell me one last time.
Yes, actually I'm pregnant. Now 5 months already.
You know the consequence, right? So I have to terminate your contract. You have to pack your stuff and get out from this place.
I'm sorry, miss.
I don't want to listen. Get out. Leave my office now.
I'm sorry. Thank you.
Assalamualaikum and hello, welcome to our presentation video. We are excited to share our exciting locations with you today. So without any doubt, let's get started. Hope you guys enjoy it.
Beatrice Fernandez, the appellant, worked as a flight attendant for Sistem Penerbangan Malaysia (MAS), which is the first respondent. After finding out she was pregnant, The appellant was told by Mas that she had to quit her job. After the appellant refused to step down, she was fired. Based on this case, in Article 8(2) of the Federal Constitution of Malaysia, which guarantees equality before the law and forbids discrimination on the basis of gender, was violated by the mandatory retirement policy for pregnant flight attendants.
A law applicable for this case, Article 5(1) of the Malaysian Federal Constitution protects a person's rights to life and liberty. Article 8(1) guarantees that everyone in Malaysia is equal before the law. Articles 8(2) prohibits discrimination against Malaysian nationals on the grounds of gender, race, descent, religion or place of birth. Section 37(1) of the Employment Act 1955 makes it mandatory for employers to pay maternity allowance to female employees on maternity leave. Section 40 of the Employment Act 1955 relates to a female employee's pregnancy announcement.
Feeling like I'm trapped in my damn mind. Tell the feeling like I'm rapping a damn lie. Tell the feeling like
In the defense of Beatrice Fernandez versus Sistem Penerbangan Malaysia and Malaysia Airlines likely argue that Ms. Fernandez's termination was lawful due to a pre-existing collective agreement mandating resignation upon pregnancy for her category of flight attendants. They might have further justified the policy with safety concerns for passengers and crew. Additionally, the defense may have argued a limited defense strategy, particularly the restricted view of Article 8 has been criticized as the case became a landmark for its contribution to the legal debate on pregnancy discrimination and the reach of constitutional protections against gender bias in Malaysian employment.
For appellant argument's part, the crux of the legal argument put forth by Beatrice and the appellants was that Section 66 violated several fundamental rights guaranteed under the Malaysian Constitution. They argued that this section infringed upon their right to life and personal liberty Article 5(1) by criminalizing their core identity based on their gender identity, thereby degrading and devaluing them as individuals. In seeking equality, Beatrice's involvement in the case reflects her commitment to seeking equality and protection under the law for individuals with diverse gender identities. By challenging Section 66, she aimed to ensure that individuals like herself are not marginalized or discriminated against based on their gender identity. Furthermore, they contend that Section 66 also violated their right to equality before the law and equal protection of the law Article 8(1). They argued that they were not in the same circumstance as other Muslim men due to their JID and should not be treated on an equal basis. They claim that the section discriminates against them by treating dissimilar persons in the same way.
A flight attendant who was terminated for refusing to resign upon discovering her pregnancy filed a discrimination claim under the collective agreement. Both High Court and Court of Appeal dismissed her claim, stating that constitutional protection do not extend the collective agreement. They also emphasized the unique duties of flight attendants and the absence of analogous positions within the same classifications. The collective agreement was deemed binding, non-negotiable, and consistent with Section 37(1) of the Employment Act regarding maternity benefits. No implicit obligation were found for the employer to modify duties during pregnancy or maternity leave. Ultimately, the petitioner's request for leave to appeal to the Federal Court was denied for failing to provide sufficient grounds to challenge established legal principles.
Nargesh Mirza, the petitioner, worked as an air hostess for Air India Airlines. The rules that applied to female flight attendants at the time were that they had to quit if they got married, got pregnant for the first time, or turned 35, whichever came first. Similar regulations did not apply to male flight attendants. In 1980, Nargesh Mirza filed a right suit in the Bombay High Court contesting these regulations. She argued that the regulation discriminated against women employees in violation of Article 14, 15 and 16 of the Indian Constitution and presented unjustified obstacles to them. Article 14 and 14 forbid discrimination based on sex, caste, religion, race, or place of birth and ensure equality before the law. Equality of opportunity in public employment is guaranteed by Article 16.
Thank you for watching our video presentation today. I'm truly appreciate your time, especially thank to my team for their hard work on this project, and not to forget our lecturer for giving us the opportunity to make a video presentation.